Namaste Bharat. I'm Duri Vatsalendra, Senior Lawyer, High Court of Telangana. There is an act called Guardianship and Wards Act, which is initially has been inculcated in the year of 1850. Now that is applicable all over India as far as the guardianship is concerned. It is not in particular with the religion community or caste and creed. Now there is a special Hindu Minority Guardianship and Wards Act 1956 wherein it is applicable to all the Hindus, Jains, Buddhists, Punjabis and all who are known to be Hindus. Now let me tell you the rights, rules and application of this act for the wards. One has to understand what is something where we say as a child. A child is, it's not the other way around, wards, rooms and hospital wards. This in legal language is the child. Minor child is usually called the ward. Now, Guardianship and Wards Act purely deals with the rights of the guardians and the obligations, rules, regulations to be followed under the Act. Anybody who wants to be the guardian of the minor are divided into three categories. A guardian by nature, natural guardian, a guardian through testament, that is through will, and the actual guardian appointing another guardian for the welfare of the child, and then de facto guardian, which usually is very rare, who is not a natural or testament guardian but acts as a guardian and takes care of the, you can say, a caretaker. Now when we say natural guardian, who falls under natural guardian? A mother, father by nature who have their child naturally born between them is a natural guardian. The father becomes a natural guardian after attainment of the age of 5. The mother is natural guardian by birth of the child itself. The natural guardian can act for the ward in various ways, like protecting his property, protecting his rights, protecting his personality, protecting his life, or anything with related to his personality and growth. Such rights are well protected by the natural guardian. In many cases, some inherited properties are also protected by the natural guardian. It is very important that when some properties are inherited, not a father's mother self-acquired, in case for some reasons, if the parents must have kept the property for the minor for the future by creating rights in the property, after attainment of majority age, the natural guardian will automatically convey or transfer the rights. In case after the attainment of majority of such minor ward, if the parents do not want to give away the rights, they can equally cancel all such rights, which is legal and applicable. Now, any inherited property through grandparents kept under the protection of the natural guardian only to protect the property until the minor becomes major cannot be reversed or called back by the natural guardian. It has to be conveyed on the attainment of majority age of such minor. However, if it's a child who has unsound mind or mentally not stable, the natural guardian will protect it until the survival of such unsound or mentally disabled child. When we categorize these three categories, I spoke of testamentary guardian. A testamentary guardian is somebody who is appointed by a natural guardian, that is, mother or father, when the parents of the child are not able to protect the future of the minor child or have some apprehensions by way of, say, their health issues or anything else. They actually keep the child protected by appointing a guardian who will protect their future and act as a guardian to this minor ward. This is usually done through will or by giving in writing of appointing and nominating a person as a testamentary guardian. Testamentary guardian will have certain restrictions that they cannot deal with the minor's properties or do anything related to the property. When I said natural guardian can protect the properties, they can protect the rents collected by the properties and keep it in the banks and etc. and do all legally. Similarly, testamentary guardian also can perform such roles, but they will not have any direct relation to the ward and shall only act as a guardian. They will not have rights to recall the properties or dealing with the properties or conveying the properties, which the natural guardian has already must have stated in the will or the testament given by them and by way of appointing the guardian. Hence, a testamentary guardian will be a guardian to the ward who is a minor. On attainment of majority age, it is up to the ward whether he accepts the testamentary guardian. However, in most of the cases, once the parents want a particular person in whom they have faith and trust that this particular guardian is the best for their child, shall not be disturbed in any point of view whatsoever until and unless the testamentary guardian misuses or abuses the powers given or abuses the minor child or has become something where he is a criminal by any act or any act which is illegal will take away his rights by the minor child who on attaining the majority age will file a petition before the courts that he has no faith in such a guardian. Now there is a de facto guardian who is not a natural guardian or a testamentary guardian, but by certain circumstances has to be a guardian. He will look after the minor ward in the best interest as a caretaker by giving all necessary things. There is another form of guardian where the court will appoint a guardian. The court appoints a guardian when it finds that due to disputes between the husband and wife, they are not able to look after the child and the growth of the child is affected in a healthy atmosphere, or it will be affected mentally and physically. In such circumstances, the court will appoint a guardian to take care of the minor child. When I talk of all these things, there is one more important aspect where by, if suppose the natural guardian renounces the world or becomes a sannyasi and doesn't want to be called as guardian, he, or even if he wants to be called as a guardian, he cannot do so, as he loses the right of being a guardian by way of renouncing the world. A sannyasi cannot protect the rights of the minor child, as he himself will have no faith in the society, rules, regulations, and the legal systems. As such, a natural guardian who renounces the world loses the right of being a guardian. So, with all these things, the categories of a guardian are into multiple forms. Sometimes, when the parents die, as I said, it is through testament, or without a testament, the court will appoint. And in de facto guardian, situations created. And in natural guardianship, there are also disputes between the husband and wife as to who shall have the custody of the minor. These are all a separate thing to be discussed in my oncoming video, where the custody rights are fought for the child. There are certain rules which I'll be discussing in the oncoming videos, who shall have rights over the minor child. However, I request everybody that, in the interest of the minor children, not to fight for the rights, but only to look into the welfare of the minor, to whom the best atmosphere has to be given. I hope I'm clear in telling you or explaining it to you all that who is a guardian. Thank you. Namaste.